Hello, my health freedom loving friends. Miste Karlfeldt here with Health Freedom Idaho. I'm here with attorney Colton Boyles. We met when baby Elijah was taken from his parents on the second day of life, I think it was, because the parents decided not to vaccinate. And he helped baby Elijah get back home to mommy and daddy. And ever since then, he's been a resource for me on all of these concerns that we as parents are having to deal with today. You know that CPS has been my hot topic because I want to know what to do when CPS comes to my door. But now I want to know what to do when these contact tracers come to our door. Have you heard about contact tracing? Everyone is saying it: testing, tracing, treatment, and isolation. So what does that actually mean? And then we hear Alan Dershowitz say we have no right not to be vaccinated if it endangers public health. So we hear that as well. And then we see some of these folks that have taken the contact tracing classes explaining what that means. Like, they're going to come to your door if they tested somebody who was positive and then that person had been around you. If you'd been at the same grocery store, they're going to show up and want to test you. So, Colton, please help us know what to do, because of course it's concerning. We want to protect ourselves, but most of all, we want to protect our little precious babes. So what do we do if these contact tracers come to our door? What would you suggest?
Well, I can only give individualized legal advice based upon a specific set of facts, but generally, for educational purposes, I can tell you in Idaho that the governor and the director only have the authority to issue orders of isolation and quarantine, and to find that, you have to go to Idaho Code 56-1001, which is the definition section. Now, that's not mentioned in the orders, but it's part of the same statute, and it governs the meaning of the words they use. Isolation is the separation of infected persons or persons suspected to be infected from other persons, right? And it involves some other contingencies there on that. Quarantine is the restriction placed on the entrance to and exit from the place or premises where an infectious agent or hazardous material exists. So isolation only applies to an infected person or someone who's suspected to be infected. Quarantine can only apply to a place or premises where an infectious agent or hazardous material exists. So if any of those elements fail, then anyone can challenge an order of isolation or quarantine in the district court, and the district court reviews it de novo, which means just as the emergency order was considered by the agency, meaning they can take in all the facts and take a fresh look at the evidence. It's like the trial court taking a look at it, as opposed to an appellate court just reviewing the record. So if you look in what the governor cites, Idaho Code 56-1003-7, A talks about an order of isolation or quarantine and what to do for a review. It says that the court can affirm, reverse, or modify the order, and shall affirm it if it appears by preponderance of the evidence that it's reasonably necessary to protect the public from a substantial and immediate danger of the spread, right? So when it comes to contact tracing, for me, if there's no suspicion that I'm infected, or there's no proof that I actually am infected, an order of quarantine and an order of isolation just wouldn't apply unless they're restricting me from going somewhere that does have that present. And so for the governor to say the entire state is quarantined and the entire state is isolated blatantly violates the statute that they rely upon to impose those draconian measures and destroy our economy. Now, Dershowitz, I think, was a little bit taken out of context with his statement based upon Jacobson, which is distinguishable in that it was a single city against a single adult person and having to do with an immunization technique that had been around for hundreds of years. Here we're talking about statewide measures, a novel virus that is akin to the common cold that's mutating, that we can't keep track of, and we don't have adequate testing for, and we're talking about vaccines that haven't even been tested. So just on a sort of basic, what we saw in the Nuremberg trials, informed consent. I'm going to be vigorously opposing any attempt to contact trace me or my family. I will not be speaking to these contact tracers because I consider them a state actor. So they're bound by the laws and the Constitution of the state. I'm going to treat them exactly like a police officer. They're going to have to get a warrant, and they're going to have to develop reasonable suspicion and probable cause of a crime, or in this case, I'm infected. And unless they can gather that data somehow that doesn't violate my fundamental constitutional rights, it's not going to happen.
Okay, so what does that mean it's not going to happen? So when they come to your door, when we have talked about CPS in the past, we've said, it's your right not to answer the door, right? And that's what I tell my kids. If somebody knocks on the door, you have no duty to answer the door and to talk to the people that are on your doorstep. You don't have to do that. You can just choose not to answer the door, right?
There are statutes in Idaho where it talks about compensation for property. So I think the section is 46/1008, and then it incorporates 1012, and it talks about a person having to conduct themselves and manage their affairs that will reasonably assist and not unreasonably detract from the ability of the state to successfully meet disaster emergencies. But my view is that none of these statutory authorities can violate a constitutional provision. Take, for example, the initial aggressor statute that gave cops the right to just arrest a person who was the initial aggressor in a domestic abuse environment. Well, police officers under the Constitution can arrest you if they have probable cause that you committed a felony, or they have to witness a misdemeanor in their presence to arrest you for it. Otherwise, they have to have a warrant. How long was that statute on the books before somebody finally decided to challenge it? And when they did, guess what? Overnight, every single Idaho law enforcement agency scrambled to reassess the policy because now all their officers lose qualified immunity and become held personally liable for violating your constitutional rights. So you can no longer come to a person's home, listen to the he said, she says, and then make a judgment call on who you think was the initial aggressor. You didn't witness misdemeanor, so now you must apply for a warrant. I think the same thing applies here. If you look at the statutes they're relying on for their authority, there's a extreme disaster that has been declared, and so the governor must still abide by the provisions of the Constitution. He can't just change the law to make it convenient. He's able to change rules and regulations, but not actual law. And so I think the same thing applies here. If there's a constitutional standard, there's a law enforcement officer that has taken the oath of office to protect and defend that Constitution, then they must continue to abide by it.
Yes, right. Absolutely right. Okay, so some of us mamas have talked about, sometimes the kids open the door because they're not thinking, they hear a knock and they go open the door. And so now, or maybe I have a guest and they open the door. So now I have this open door to the contact tracers who have been trained, and possibly a police officer. We don't know. So what then? What if they start asking me questions about where I've been? Have I been to this certain grocery store? Because again, I don't know what it is that they're looking for, right? I don't know where it is that they're thinking I could have possibly contracted COVID or been around someone who did. And so now they're at my door asking these questions, which could come back to haunt me if I answer them incorrectly. So what do you suggest?
Right. I generally counsel clients not to talk. In some cases, it helps to dispel a suspicion. The cop goes, hey, I smell some marijuana. And you're like, it's absolutely not marijuana. We have stuff in our local lakes and rivers that smell like that. You're smelling skunk weed right now or whatever, right? Sometimes it can help to dispel suspicion, but generally people are just giving more evidence for them to base a reasonable suspicion they committed a crime. So I generally counsel clients not to talk. Call an attorney that you're confident in as soon as possible. Not just any attorney, get one, spend some time beforehand, develop a relationship. I've had clients tell me in the past that their family law attorneys, their CPS attorneys say, oh, just go on into the Department of Health and Welfare, let them record you and do a statement and talk to them. And if anything gets weird, give me a call. Absolutely not. I consider that malpractice. You should never volunteer any information to, the director is a law enforcement officer. He has the power to enforce the health laws, meaning he can point a gun at your head and tell you to do something. So I think the answer to the question is governed by the Ninth Circuit, their 2018 case, Demaree versus Peterson, and a lot of people have been talking about it. They state that parents and children have a well-established constitutional right to live together without governmental interference. This is case 14-16-207. The quote here in the holding is that there are narrow circumstances in which the government may constitutionally remove children from their families temporarily without judicial authorization. In an emergency, government officials may take a child out of their home and away from their parents without a court order when officials have reasonable cause to believe that the child is likely to experience serious bodily harm in the time that it would be required to obtain a warrant. I think that's the applicable standard here, and all those elements are going to have to be met. So unless it's a very, very narrow circumstance that serious bodily harm will occur, there's absolutely no justification. And so it's a social interaction at that time. So if you want to get contact trace, go for it. But if you don't, I don't see any legal requirement at this point that would force you to do it. And if the governor is going to order that, it's blatantly unconstitutional. What happened to the legislature? They may not even be able to do that. I'm not even convinced the legislature could pass an appropriation and a bill to say that you have to get contact trace. I think that would fail in the courts too. So if the legislature can't do it, I doubt the governor can do it. He has even less power.
Nice. Wow. Well, that is a huge relief to me, as always, when I call you and I start to get freaked out about what is going on today. And I just also want to reiterate what you said, in that having a good constitutional attorney, it's worth its weight in gold. I mean, having access to your knowledge and knowing that you come from a constitutional foundation, it brings me so much reassurance that my family's going to be okay, and helps arm me with what to do. So I just want to reiterate, folks, you don't have to open the door. And if you do open the door, you don't have to answer their questions. You can ask them kindly to get off of your doorstep because they're trespassing. And if they don't have a warrant, they can't come in. So I guess, yes, it is up to you if you want to participate. For me and my family, we won't be participating because I'm going to stand on my constitutional rights, which protect my natural rights. And if we don't start walking in those rights, we're going to lose them. So that's just my soapbox. That's my 2 cents. Colton, tell us about your practice. Do you want to give it a plug?
Sure. Boyles Law, PLLC. I operate out of North Idaho. I'm barred in Washington, Idaho, New Mexico, the Federal Court of Claims. I'm currently setting up a practice to handle vaccine and injury compensation claims in the Federal Court of Claims, and doing a lot of work with nonprofits, a lot of stuff with veterans, widows, and children. I specialize in commercial litigation and civil areas of law in general, and have a lot of fun, get to do a lot of research and meet a lot of incredible people. So happy to help. I'm dealing with cases with nurses who are being forced to take the flu vaccine and are getting terminated for that. We're being successful with religious liberties, dealing with cases of people who work at old folks' home that they're saying they're going to require certain testing and take their blood. We're being successful there, helping people who aren't able to access their wives when they're having a baby in the hospital, which is ridiculous. Or if they have a mentally incapacitated person who got in an accident, they're saying you can't go help with care. So I really like that area too. So I've incorporated a lot of that into my new practice outside of just commercial litigation because of the way it just impacts people's life. So you can see my website at cboyleslaw.com and call Miste, call Health Freedom Idaho. I've authorized them to share my email address and my cell phone number. If you need me, I endeavor to be available whenever you need me, because I know these matters are time sensitive, and it's way easier to not dig a hole and jump in it than to try and dig your way out of a hole.
Yes. Yes, yes, yes. Thank you. Thank you so much, Colton. I appreciate it.
Thank you, Misty.